Your Honor, this is Brian Lennon on behalf of Governor Snyder. The prosecutor is correct. Yesterday, I did send a letter to Solicitor General Fadwa Hammoud, pointing out a number of things, including the fact that the indictment is fatally flawed because it's charged Governor Snyder with crimes allegedly that occurred in Genesee County. These crimes, which are both false but fatally flawed because they charged it in the wrong venue. At all times during the indictment, Governor Snyder was at his office in the Romney building in downtown Lansing. So the reason we held off, we did file a discovery request, and we attached that letter to that discovery request. But the reason we didn't file the motion to dismiss is we're trying to give the government an opportunity to recognize this mistake and voluntarily dismiss the indictment against Governor Snyder.
Okay. Well, normally with these types of cases, our procedure is to have the defense attorney contact the prosecutor prior to the pretrial, and at that time, there's a document exchange and other matters taken care of, and then they, if necessary, then they come to court, speak with the judge. And prior to this pandemic, the attorneys would show up in court and they go to a conference room and talk and exchange documents and everything, and then come back to court. Now, normally my procedure today would be to send you to a breakout room to talk about these matters, motions, exchange of documents, any areas of agreement or disagreement, and then come back and put whatever on the record. And what I'm hearing is you do not want to do that. You want an adjournment so that you can check out this motion to dismiss, or what?
Yes, Your Honor. Frankly, and there's because this is a unique process by which these charges were brought to discovery, there's some other issues regarding the discovery that I think we need to discuss with defense counsel as well. Frankly, I anticipated a motion pursuant to MCR 6.107 because this indictment was issued pursuant to a grand jury, but I haven't seen that yet. But yes, for purposes of today, Your Honor, we're just asking for another court date so that we can observe and respond to defendant's motion to dismiss. And perhaps in the meantime as well, we will be having conversations regarding discovery and those issues.
And Your Honor, for the record, this is Brian Lennon for Governor Snyder. We'd like the opportunity to speak with the prosecution now. We have some other questions that will help educate us on the timing. The prosecutor mentioned that we did have communication with an assistant or a partner in my office. That's going to be focused on the supposed millions of documents and hundreds of devices. So that conversation is going to happen later today about how we can facilitate that exchange of information. The prosecutor also mentioned the discovery that is required to be submitted within 14 days to the chief judge of the circuit court. We plan to do that because that is the way the statute says we must obtain that. But we think we should talk today. One of the important discussions, and come back on the record, one of the important things that will educate us on the timing will be whether the prosecution used the taint team when they did searches of this material. If they did not, that will significantly impact the timing and the numbers of motions and requests for evidentiary hearings that we need. We have it on good belief that a taint team was not used. We'd like to talk to the prosecution about that in a conference room today and come back and put those concerns on the record. So we're not asking for an adjournment right now. We need more information before we can talk about a schedule.
Your Honor, if I might, Molly Kettler here for the record. Two things. First of all, we have a public court proceedings in this state, and the defendant, Mr. Snyder, appears to have turned his camera off. I would ask that he put his camera back on. The people have a right to open court proceedings to the best of our ability, despite the pandemic. Second, as to the substance of Mr. Lennon's comments, we're very much looking forward to receiving actual motions that the defense may file on behalf of their client, and we're very much looking forward to responding to that. We don't intend to litigate this by emails and informal discussions, but rather as we would any criminal case. And we would like to have motions filed as is proper under the court rules. and have the opportunity to respond to those motions.
All right. As much as possible, I want to, excuse me, I like to keep this case in the normal track as any other case. And all this Zoom stuff is, still pretty new. In court, only one attorney speaks. So, it might be said, I've had at times up to 10 or 12 people, attorneys or assistants or whatever in court on the last case I had of this nature, and only one attorney can speak at a time. And if we want to have some bifurcation where one attorney handles one matter and somebody else handles another matter and the court has notice in advance, that's fine. But other than that, I prefer just to hear from one attorney, just like we normally do in court. In regard to Mr. Snyder's appearance, there was a motion, a request was made that he not have to appear today, which was granted because I don't require defendants to appear if there's no reason for them to appear. In the absence of objection, I said he did not have to appear. But once somebody does need to appear, I would agree that they probably should be on camera, just to make sense. And if he did not want to appear, he had that option pursuant to the prior request of his attorney. In regard to trying to keep the case normal and on track, I would like the attorneys to meet today, because these adjournments, they seem innocuous at the beginning of the case. And when we went 9 or 10 months out and everybody, why is this case taking so long? This is why the case takes so long. We don't know what's gonna happen down the line. Allegedly millions of documents, electronic devices, discovery. I don't know how long this case might take, but in August or September or this time next year, somebody could be looking back and say, whoa, maybe on that day, not only today, but in other days, we should have done more. So I'm gonna do as much as I can to keep this case on track. And so to that end, I would like the attorney to at least talk today, and you may not make much headway, but at least you'll know where each of you is coming from. And but prior to that, I had a couple of questions myself. We handle a lot of misdemeanor cases and felony cases, but not necessarily cases of this extensive nature. So my first question is, what is a taint team?
Be happy to explain that, Your Honor. And for the record, Your Honor, with respect to Governor Snyder's appearance, I did call on Friday, but I did not get word back about the court granting our request. So I apologize for that, but I'll make sure that we've got open lines of communication with your chambers on that. But Your Honor, it is standard practice, prosecution 101, whenever prosecutors elect to use search warrants and they have a reason to believe that in executing the search warrants, they will be uncovering attorney-client privilege and other privileged information. It's standard practice, and it's done to protect the integrity of an investigation. And so a taint team is made up of prosecutors and investigators who are not part of the prosecution team. They go through the evidence first to separate what is attorney-client privileged or other privileged information before they let the investigators and prosecutors who are handling the case look at it. It's a fundamental practice. The Attorney General's office under Dana Nessel routinely uses this. We have reason to believe that that was not used by this prosecution team led by Solicitor General Hammoud and Prosecutor Kim Worthy. It is a fundamental thing that, if not employed as a basic level, can disrupt the integrity or challenge the integrity of the entire investigation. And I simply asked a simple question: yes or no, was a taint team used? Because that will inform the length and the types of motions that we're going to be needing to file right out of the box. It's a simple yes or no question that I'm asking the prosecution to answer, and that I asked Solicitor General Hammoud in a letter last night and have not received an answer. Happy to meet with them this afternoon, but it's a simple question that I think should be answered on the record right now.
Well, that's something you can discuss in the pretrial. There's also a paragraph in here that says transcripts were leaked to various news organizations. Is that like speculation, or is something that's agreed upon, or what?
No, Your Honor. I believe it was sometime in 2020 or 19. I'll have to check on that, but it was well publicized that the investigative subpoena transcript for Rich Baird and Valerie Brader appeared in news media and in news articles. It's further my understanding that this happened and then was brought up in the civil litigation before Judge Levy, where some type of arrangement was made so that the investigative subpoena materials could be provided, I assume, under protective order to the litigants in that case. But I actually saw with my own eyes, as I'm sure others did, the transcripts from the investigative subpoena process, which was run by Judge Kinney in Wayne County. Those things are supposed to be held. It's a secret proceeding. Somehow they were leaked to the press. We just want to know how that happened because we're confident, at least they should, that the Office of Special Counsel, which had custody of those, would have investigated that leak. So we'd like to know what else was leaked, as well as other questions in that. So it's not speculation that they were leaked, Your Honor. We all saw them. They were in the press.
What is a Celebrite report?
Yes, Your Honor. So a Celebrite report is a report that is done of what is extracted from a electronic device, specifically a cell phone. It has been well publicized by the Office of Special Counsel that they looked at hundreds of devices. And it's also well publicized that they did a search warrant on the other side of the conflict wall, where all of Governor Snyder's and his lawyers and other advisors had parked all of their devices and materials because of the ongoing civil litigation when they left office. So the Celebrite report is a trademarked type standard report that essentially puts in a spreadsheet all of the information taken from a mobile phone.
Oh, okay. Thank you. I think I know what a Faraday bag is, but just in case.
Yes, Your Honor. Again, a standard practice when seizing electronic devices is that can transmit and receive communications is to use a Faraday bag, which looks like a aluminum foil bag, to put the devices in so that nobody in transport or where they're being stored can log into the devices to make changes, delete, whatever, before the information is actually extracted. Again, standard practice.
All right. Paragraph 18 talks about social media account for any and all members of the Executive Office of Governor Snyder or any other witness. Are you like asking for like anybody who testified like all their personal social media, or I'm not sure how extensive that request is?
We're just asking for what the prosecution team has in their possession, Your Honor. There were, as the court knows,
like in their possession or in the possession that they would intend to use.
Yeah, well, we'd like to know kind of, again, what personal emails and what social media they may have captured in the course of their investigation. It's a grand jury investigation now. It was an investigative subpoena process. Both are very private and very secretive proceedings. We just don't know what they have. So to the extent that that needs to be modified, Your Honor, and clarified, we're happy to do so. But because their predecessors chose the investigative subpoena process, which is, other than the leaked transcripts, is kept secretive, and now they've used the secretive single judge grand jury, we just don't know what they have. So we're asking to see what they have, we may have subpoenaed in the course of their investigation.
All right. Would anybody for the prosecution, did you have any comments on anything we just discussed?
All these matters, I'm sure, will be discussed later today with counsel. The only thing I do want to put on the record, Your Honor, as defense counsel mentioned Office of Special Counsel, I want it clear and on the record that the Office of Special Counsel was the prior prosecution team. It's not the Office of Solicitor General or the prosecutors that took over this investigation. So I just it understood that the Office of Special Counsel was a separate thing started by former Attorney General Bill Schuette, and it was no longer with the Attorney General's office when these indictments were handed down last Thursday. Thank you.
Thank you.
Your
All
Honor,
right, well, go ahead.
That's helpful. I just want to be clear because we're obviously have to modify this and also other pleadings as to how we should refer to this investigative team. Is it simply the Office of the Solicitor General? Because that seems to include all of those who appear for the state in court, in the Supreme Court on the other side of the wall. So just want to be clear, how should we refer to the investigative team led by Prosecutor Worthy and Solicitor General Hammoud?
This is it's just the Attorney General's office, Your Honor. I know we're talking semantics here, but the Office of Special Counsel was created with Special Assistant Attorney Generals in order to investigate the Flint water crisis. Now, although we do have Special Assistant Attorney Generals in the form of Molly Kettler, I know Prosecutor Kim Worthy is assisting on this investigation, but the other prosecutors that are going to be prosecuting this case are all Assistant Attorney Generals. So I would just say the people or the Attorney General's office.
We'll work it out, Your Honor.
Yes, thank you, Your Honor.
All righty. One last question. I'm not sure what Veolia is. Is that a company or a person?
Yes, Your Honor. Veolia is a company that had been retained by the state to help address the issues of water in Flint. We have ordered a transcript of the federal court case where we believe some statements were made by the state of Michigan with respect to Veolia's role and that could bear on these charges. So Veolia is a company that was retained at some point to help with the Flint water matter, and I think there's been representations made by the Attorney General's office on the other side of the conflict wall as recently as last Wednesday with respect to Veolia's role in this tragedy. So we believe it could go to Brady. It could also go to other issues. So that's why we're requesting that information.
All right. Well, I'm going to send you to a breakout room, and I understand that the discussion at this point may not be extensive or in-depth, but at least you can see where some of these matters we discussed already, and probably some more that I did not address, and just see where the areas of disagreement are, and basically when we come back on the record, where we go next from here and what the time frames are.
Your Honor, so may the governor be excused?
Yes, he may.
Thank you, Your Honor.
Your Honor, this is Alex Russick. I represent Mr. Croft, and I don't believe we're on the record for him yet. But without objection, I'm sorry, Your Honor.
I'm going to call your case next.
Okay, thank you, Your Honor.
Okay. All right.
Thank you, Your Honor.
You're welcome. No, because we can't stay here for a minute because we need we're gonna need the prosecutors for the next case.
Yes.
People of State of Michigan versus Howard Croft, case number 21-0047. State your appearance, please.
Good morning, Your Honor. Brian Oskowitz on behalf of the people.
Good morning, Your Honor. Special Assistant Attorney Molly Kettler on behalf of the people.
Good morning, Your Honor. Alexander Russick on behalf of Mr. Croft.
Morning, Your Honor. Jamie White here on behalf of Mr. Croft.
Sorry, what's your name again?
Jamie White, James White, P56946.
Okay.
Yeah.
Right. You're not on video, are you?
No, Your Honor. I'm in a public setting, but I could go on video if you prefer.
Oh, it's okay. I just want to make sure who I'm looking at here. That's fine.
Sure.
All right, Mr. Russick, there was something you were saying?
Yes, Your Honor. A lot of the issues that have already been addressed in the previous case also apply in this matter. Ms. Kettler and myself, we had a discussion on Friday, the arraignment, and we only learned of the indictment on Thursday of last week. So we're working together to get things moving as fast as possible in a case that undoubtedly is going to have just a massive amount of discovery in it going forward. So without objection from Mr. Lennon or from the Attorney General's office, I think that going into a breakout room right now, that would be beneficial. So maybe we can get some timelines for the courts to start looking at to move forward to keep things on track.
All right. Anything else from the people?
No, I agree, Your Honor.
Okay. Now,
Though, Your Honor, I will just say,
breakout rooms at the same time or a separate breakout rooms, or how would you like to do this?
I think separate breakout rooms for these particular defendants, Your Honor, because they're different entities. I know Mr. Croft was from the city of Flint, while Mr. Snyder was from the state of Michigan, so it'd probably be beneficial to have separate breakout rooms.
And Your Honor, I'm not opposed to having one breakout room because of the crossover of issues, especially in regards to discovery. But of course, I would leave that in the discretion of the court. And if Mr. Lennon doesn't want me in there either, that makes sense.
All right, well, we'll do separate for now, and we'll send the prosecutors with defendant Snyder first, and then when you finish, you can call the court, let us know, and we'll send you in with defendant Croft, and then we'll
Your Honor,
come back on the record.
is there a process? You said a breakout room. Is there a process that your court uses for this? I'm sorry, I'm not unaware of it. Or should we just work it out amongst ourselves?
No, you're gonna get a message to click and go into it.
Understood. Thank you, Your Honor.
And then I said the electronics are somewhat shaky, but so you just get disconnected or anything, just give us a call and we'll try to remedy it.
Very good, Your Honor.
Your Honor, may
Okay.
Mr. Croft be excused?
Phone number would be 810-766-8981. That's the direct line to my court.
I apologize, Judge. Could you repeat that, please?
810-766-8981.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor,
Thank
may
you.
Mr. Croft be excused from the proceedings today?
May I ask this objection? Yes. All right, thank you. These are the.
Thank you, Your Honor.